Welcome to this new episode of the Dynamic Antitrust Discussion Series. We've had a number of panel discussions with scholars and practitioners, and now we're starting a new series of interviews with leading antitrust scholars and enforcers. And as part of this new series, we are delighted to have Commissioner Noah Phillips of the Federal Trade Commission. Welcome.
Aurelien, thank you so much, and thanks to ITI for having me.
It's a great pleasure. So in this discussion, we will engage in antitrust topics and competition law issues, but also we will know more about the individual and your background and what your views and values. And I think that's very important to know you better for the audience. So let's get started. It's good to be back in person first, right?
It's very good to be back in person.
To see each other. So that's very great. What does it mean to be back in person at the agency, at the FTC? Is it feel much better? Can you do things that you weren't able to do during this COVID pandemic?
So actually, let me start by just table setting that I'm supposed to say. What I'm going to say is just my own view and not necessarily the views of my fellow commissioners or of the view of the agency as a whole. So I think we did a really good job as an agency when the pandemic started of kind of moving our systems over to being remote. And that's both with respect to public-facing matters and also with respect to the work that we do internally. So I think we pivoted well and continued to be really productive during the pandemic. But I do think, as with any context, and certainly a context where you have different people looking at a similar set of facts and trying to draw conclusions and thinking through the implications of what you do, there is a lot lost when you're not there in person. And so for me, and in my little office, the Commissioner Phillips office, I think that one thing that I have missed is the opportunity to be in person with my staff. We can Zoom together, we can talk together, but I know that I do better personally when I'm with other people. As an agency, we're not all back at the office yet. That's sort of an iterative planning process. Eventually, I hope we get back there, but I think we're going to try out doing some more things remotely on a more permanent basis and see how that works. If you go to the halls today, not everyone is back, but there are more people at the office than had you been there, a year and a half ago.
Yeah. So you recommend going back in person because you lose some parts in the investigations or in the daily work of the agency, right? I think that's a great point to learn. So how do you work with the staff? I mean, as a minority commissioner, what does it mean to be a minority commissioner in an agency?
So, in theory, at least, all the commissioners are kind of equal. I mean, the chair is the first among equals, and she directs the agency on a day-to-day basis and directs a lot of the enforcement strategy, that sort of thing. And the chair usually gets first look at almost anything because they control the agenda. Beyond that, the way it's supposed to work is that the commissioners get similar information from staff and have an opportunity to visit with staff to discuss issues. I think we're at our best when we get a chance to really dig in on the content. We have time to consider it. We get answers. I think in the last year, we've had some trips and falls. We haven't always lived up to that promise. But I hope that those become more the exception rather than the rule. One of the things that any commissioner can do, whether they're in the political majority, the political minority, is express their own independent view. So for example, there were certainly times when I was in the majority where I didn't agree with what the commission was doing. And so each commissioner has an opportunity to sort of have their voice heard. And if you don't like something, you can vote against it, you can write against it. That can complicate things. It makes our agency, from a competition perspective, a little bit different from what you might find at the Department of Justice, where at the end of the day, it's the Assistant Attorney General and up the chain from there. But that's not just a minority-majority thing. That's a factor. That's sort of the congressional design of having an agency composed of up to 5 people.
the congressional design was also to force kind of compromise, was to also to reach a bipartisan support in the agency's guidance or the agency priorities. Do you think that, yeah, as a minority commissioner, do you think that this search for bipartisan compromise has been lost or has been a bit undermined over the last few months, over the last year?
I think from time to time, we've seen things that are not conducive to that. So failing to share enough information in advance about certain issues. But we've still, I think in a lot of areas, found room for bipartisan compromise. And to be clear, it doesn't always mean consensus. So for example, recently we adopted a proposed regulation for auto dealerships. And I joined my Democratic colleagues, and my Republican colleague didn't agree. And that's perfectly normal and natural. What I think is critical, and what has as a practical matter led over time to a greater level of consensus, is a real exchange of ideas, taking real time to evaluate and to think through things. And one of the benefits I think that we've had at FTC in particular, even apart from some other, historically speaking, multi-member agencies, is that we've been able to have a level of consensus. And so we've had a level of kind of bipartisan policy stasis over time.
And greater at the FTC as opposed to other federal agencies?
Yeah, I think, when I was coming through my nominations process, some of the members of the Senate would say, don't be like that other agency. The FTC has had a really good bipartisan way of working, and we want you to honor that. We can't always get there, but I think at the very least, we should try. And when we do, when we try in earnest to get there, I think one of the things you see is policy that lasts beyond administrations. And that's helpful to us as enforcers. I think it's helpful to businesses who are trying to plan. I think it's also helpful for consumers who have a greater sense of what the rules of the road for the businesses with which they're interacting are.
Yeah, the legal certainty, or is very fundamental to the business life.
Yeah, wherever you think the policy ought to land, I think most people agree that it's not good to have it swing back and forth. And that's something that I worry a lot about, because I don't think, again, it's conducive to a good business environment and thus a good consumer environment.
So you are an attorney, and you've prior to the FTC, your legal career started in New York. You clerked for Judge Edward Prater at the Court of Appeal for the Fifth Circuit, and you then practiced as a litigator at Cravat Law Firm and Steptoe Johnson here in Washington, D.C. And then you served as chief counsel to the U.S. Senator John Cornyn in Texas for the Senate Judiciary Committee. And one of the areas of law have become over the years antitrust, and of course it's very very relevant for the FTC. How have you been interested in antitrust, and why is antitrust interesting at all?
So, my first real exposure to antitrust was as a law student when I took an antitrust course. And then when I got into private practice, antitrust was part of what each of the firms for which I worked did. So I did some merger stuff and I did some litigation stuff. So that was part of my practice, not all of it, but part of it. When I came to the Hill to work on the Judiciary Committee for Senator Cornyn, the cool kids, they do like immigration and crime and constitutional law and judges. And the rest of us—
We're not cool.
No, still not cool. Still working on that, maybe? I don't know. I spent a lot of time on kind of some of the wonkier civil law issues when I started. I eventually became chief counsel and dealt a lot more with things like judges and the Constitution. But if you had asked, who is Noah Phillips circa 2013, 2014, people would say words like patents, right? Which is, again, not what the cool kids were doing on the Hill. But one of the things I like about what are traditionally considered some of the wonkier topics is you can really spend time thinking not just in a partisan fashion, but really a lot more about policy and about the implications of policy making. So that was always an area writ large that I enjoyed, and antitrust is part of that.
So the idea of a bipartisan rational regulation is precisely what also interested you, like having economic regulation, economic intervention in the marketplace that makes sense is something that also triggered your interest into antitrust, patents, all these aspects, right?
Very much so.
Yeah. And so what is antitrust if you had to define antitrust to a law student or to a layman? What's your definition of antitrust and antitrust laws in particular?
Yeah, I mean, I think above all, I think the FTC Act is really useful as a guide in this regard. What we're trying to do is protect competition, to eliminate from business behaviors things that prevent the market from working. And that's a little bit different from other kinds of economic regulation, where maybe you have a particular thing that you object to that the market is creating, like an externality that's bad, and you want to get rid of it. So the statute says competition, and my view is that competition is what we're protecting. And one of the things that I find really interesting, like if you look at the president's executive order from last July, in the name of competition, he proposes regulation after regulation after regulation. And the idea of regulation fundamentally, as I see it, is we don't think this problem is going to solve itself, right? We don't think free interaction of firms and individuals is going to deal with the issue. So we need the government to step in. Like we need a rule, you think about it, to protect labor, or we need a rule to redistribute income, or we need a rule to reduce pollution, whatever it is. If you think that the market is going to solve problems, if you think competition will be the solution, and it often is, you think the role of regulation ought to be less. If there is something you want that you don't think the market is providing, then that's the argument for regulation, right? Which is you're putting the state in and you're impacting the competitive environment. And one of the things that's really odd these days is the same people who will call for more antitrust to achieve a given goal will also call for regulation. And there's like a logical tension there, right? Do you think that competition will result in the thing you want? Greater distribution of income, higher wages, less pollution, whatever. Or don't you? Because if you do, antitrust, and if you don't, regulation.
That's a key fundamental part, because it's also the regulation of competition, the ability for governments and enforcers to regulate the market is also, as you rightly pointed out, is a disbelief in the way the market can solve problems and can self-regulate. It's a skepticism toward self-correcting market failures.
Right. So to me, you think of the sort of, on some level, worst example of this, which is price regulation. So we rely on prices in a market as a signal, right? They help supply and demand meet. They tell companies, we need more of this, we need less of this. That's what a price does. It also, of course, impacts consumer behavior. When the prices go up, consumers buy less. When they go down, they buy more. This is almost always true and generally how we think about things. We don't like it in antitrust when companies set prices. Not only is it illegal, it's criminal, right? We have the highest penalties available to root out that kind of conduct. We assign what we call in antitrust law per se liability. The government, under certain circumstances, has regulated prices. The outcomes have been very bad, and that's consistent with what we think of when we think about per se liability for price fixing, because we like prices to move. That helps the market work.
Yeah, so you're hinting to the fact that perhaps the worst of all monopolies is government created monopolies sometimes, and some the marketplace can also, by this process of creation, destructions, and self-correcting, can self-correct in somehow. So the ability for the agency or for antitrust law to intervene has to be very laser sharp, right? Has to be based on economic evidence and fact finding exercise. And that's the key role for the FTC, for the agency, because the FTC is an expert agency. So how do you see the FTC's as an expert agency on antitrust fulfilling its role, and how can it improve fulfilling this specific role of having rational and very reasonable interventions in the marketplace to promote competition?
So let me actually come back to that and start with the beginning of your question, which, and this is the like Schumpeter Project, and right, Schumpeter, like others, very concerned about the kind of monopoly that results from a certain kind of government intervention, where government comes in and prevents the market from working, prevents that competition, and so you get much more lasting monopoly because competition with that monopoly is illegal, right? It can't happen under the law. One of the greatest things I think that the FTC has done historically is advocate, in particular with state governments, against the kind of regulation that displaces competition. So an example are COPAs, certificates of public advantage, which states will sometimes adopt to allow illegal hospital mergers to take place, or certificates of need laws, where in order to build more hospital beds, you have to apply to the state and show that there's a need. We see a lot of problems in hospital competition. If you look at our merger litigation, it's often involving hospitals because of the problems that those mergers can sometimes create. And so state laws that say you can't enter unless you get permission from us, kind of a mother may I from the government, can be really inimical to competition. So, you know, we've advocated against those. We've advocated against COPAs. We've advocated, those are certificates of public advantage. We've advocated against, you know, occupational licensing. We've tried to limit what's called the state action doctrine. And I think that's been some of the most important work that we've done over time, because it goes to the heart of something that can not just displace competition in a more immediate sense, but really on a permanent basis, because we think the competition is good. So to the second part of your question, you know, how do we approach as an agency like a rational scheme of antitrust enforcement, and how do we rationally approach regulation? I think critically, we go back to the original scheme that Congress designed. So there's sort of a debate that goes on in 1914 in Congress, you know, should we be a law enforcement agency or should we be kind of a research institution? You know, the historical analog, not analog, but the predecessor to the FTC is the Bureau of Corporations in the Department of Commerce. And it's set up to help advise companies what's okay, what's not under the 1890, the antitrust law, the Sherman Act. And I think we have all these tools to study the market, and I think we're at our best when we're taking a real sober look at a concern that folks are articulating, and we're examining it, you know, without bias. We're applying real expertise, not just preconceived opinion, and we're issuing reports, which we sometimes do, and that effort can inform two really important things. One is legislation, right? So historically, over the course of the life of the agency, we've seen the FTC go to Congress and say, look, we've seen this problem. We've studied this industry. Here are some proposals that we have. It can also impact what we do as a matter of law enforcement. So I'll give an example of this. We had a pay for delay case a few years ago called Impacts. And in looking at the legal test in that case, one of the things we were asking about is, could they have achieved the same efficiency with a less restrictive alternative? That's a term of art in antitrust law, but basically, could you have gotten the goods without the bads? And courts over time have been pretty skeptical because they don't want government or the law or courts stepping in and saying, we think you could have done it this way, when in fact you couldn't have done so. But in this case, we did something different. We relied in our ruling on the case on information we had collected over years. Like we looked at the market and we said, you could have done it differently, and here's how we know it. Here's all of this evidence. And when the court looked at the question, they said, yes, that's right. So I think we have an ability in a way that other agencies don't, because they might have to do their research in the context of law enforcement, like, you know, an investigation. We don't. We can ask questions. And I think when we're at our best, we're spotting real issues. We're asking the questions in a sober fashion. We're analyzing the data that come in, and we're using it both to inform our law enforcement and to report back to the public.
Another good example would be merger retrospective, right? Where you collect information of what you've done over the last years or last decades on mergers and how you can improve merger control, right? So it's about information gathering and data collecting, so to improve the expertise. So another question on precisely the you said it's about expertise and report drafting. But we cannot avoid this debate those days about whether the FTC has some sort of hidden legislative role when it comes to rulemaking authority on unfair method of competition. So there's a strong ambition for the current leadership to engage in what is called unfair method of competition rulemaking at the FTC, which is basically allowing the FTC to issue some legislative rules of how companies should regulate, should compete on the marketplace rather than being solely an enforcement agency. What's your take? I mean, you've spoken extensively on those issues, but for our audience here, what's your take on the FTC rulemaking ambitions when it comes to unfair method of competition?
Sure. And let me start by saying, referring to something I mentioned earlier, you mentioned the ambitions of agency leadership. The idea that we can make antitrust regulations is also something the President of the United States put on paper about a year ago. Just to contextualize a bit, I think it's important for the audience who aren't experts to understand, from 1890 to 2022, 132 years, antitrust in America has been on a case-by-case basis. We've looked at particular matters, we've looked at the impact of particular conduct in the market, and the law has arrived at its conclusion. The idea here is to replace some, or I suppose in theory all, but really some of that with regulations for the whole economy. We're not just looking at what a company did in a particular case, but we're saying this kind of conduct, we're just going to regulate it for the whole economy. That is a major shift in the way that one does antitrust.
Shift from ex post to ex ante regulations, right?
Right, and not just one company, but all companies. So the place I start with this is, I think the FTC made it up in the 1960s. This notion that we have general rulemaking authority for the entirety of our statute was something that no one at the agency mentioned from 1915, when we opened our doors, until, as far as I can tell, some point in the early 60s, when lawyers looked at some of the language and thought, hey, wouldn't it be easier if we didn't actually have to prove a case? We'll just make a regulation for the whole economy. So they did get a court to bless it, the idea, in the early 70s. The FTC at one point made a competition rule, but never enforced it. So the question is, on some level, still academic. But I would argue from a legal perspective, we don't have the power. It's not actually there in the statute, first. Second, if it were there in the statute, I think this would raise a serious constitutional problem, which is the power would be so broad, at least, or especially, as current leadership and the President of the United States imagine it to be, that it would effectively be a delegation of legislative authority from the Congress to an agency, which is not allowed under our Constitution. There's also a policy problem, which is, if we look at Justice Brandeis and Chicago Board of Trade, antitrust is at its best when it's looking very specifically at a kind of conduct in a particular case. That's how we do our work. Rules are something different. If you look at the Administrative Procedures Act, sometimes what you have to do to sustain a rule can be less demanding than what you have to do to prevail in a case. And that makes almost no sense, because the impact of a rule is much greater. So statutorily unfounded, constitutionally suspect, and as a matter of policy, a pretty bad idea. What you're talking about here is essentially complete authority for a majority of commissioners on a 5-person agency to set rules for almost any part of the economy. I'm not sure why we want that.
The irony is that, you just mentioned Justice Brandeis and these followers call themselves Brandeisians, and Chicago Board of Trade. It's interesting because he himself introduced the rule of reason. He himself wanted to have the balancing exercise of courts and more exposed, where you discuss the pros and cons of business practices. And so it's quite an irony for Brandeisians to disparage the rule of reason itself in order to...
In a case for the defendants.
Right, right. So just a truncated rule reason, at least in that case. But so it's very. We'll see how it goes. But it also seems that the Supreme Court is not very willing, according to last decisions, to grant rulemaking authority to federal agencies very generously.
Yeah, I mean, I think what we've seen, we saw this with the eviction moratorium, we saw it with the vaccine mandate, we saw it just the other day in the context of the Clean Power Plan. The court is, when agencies are making grand claims on where their authority applies or on how it applies, when agencies are getting very creative in reading statutes, when they're purporting to regulate a lot of the big social issues, whether they're reserved for the states or things that we think of Congress normally as doing, the courts are skeptical of those claims. And what I'm saying with respect to competition regulation, I don't even think it's there. But certainly, if it exists, it would only apply to what our statute covers. And the bigger you go, it seems the courts are saying, the more likely you are to run into legal impediments.
From a very practical managerial point of view of the FTC, isn't it just too much resources focused on rulemaking rather than enforcing? There's also a trade-off. It's not like rulemaking as opposed to nothing. It's rulemaking also instead of these very resources dedicated to enforcing the current antitrust laws.
Sure. I mean, I want to be fair to those who would regulate and make rules. I think part of their argument would be is once you have a rule, you have a greater deterrent effect, you have more clarity in the market, and so you achieve an enforcement efficiency. And I'll give an example. So while they're still at the earlier stages, I have voted for rulemakings, the beginnings of rulemaking processes in a number of instances recently. So I'll give two examples. One is an auto rule we did recently, which I mentioned, with respect to how people deal with their auto dealerships. I don't want to get too much into value judging because the rule will come back before the commission after public comment. But one of the things it says is you can't include add-ons to the cost of the car that produce no value. So you can't sell, nitrogen-filled tires when the tires already have nitrogen and you're not doing anything new with tires. The rule like that, or another proposal that we're pursuing, which is to ban impersonating the government. These are areas where we have practice in enforcement. So we've looked out at the market and we've said, this is a problem. And we know it's a problem because we've done work on it time and again. And so we think it's time for a rule. And in both of those instances, you have clear statutory authority. So where we've got clear authority, and where we're going after something which is bad, and where we have experience as an agency spotting that bad and understanding its impact and knowing that just enforcement isn't doing the job, there I think there's a role for regulation. But shorthanding each of those things, I'm less convinced.
Right. So let's move on more on this year at the FTC with the new chair. There's been you've raised a number of criticism, both substantive and procedural, I will say, right? So I think the substantive criticisms is this current, as we say, assault against the consumer welfare standards and innovation concerns, and also the procedural aspect of the lack of stakeholder engagement. And I think we've seen that very recently with your report with Commissioner Wilson, where you disagreed on this well, I think it was this report on online harm, where you criticized the lack of stakeholder engagement before the issuance of this report. So when it comes to this new view that is personified by the populist antitrust, how do you see these arguments? Are the substantive arguments on the consumer welfare standards more important than the procedural arguments? Are they equally important in terms of how you run an agency, how you communicate with the public is as important as the view of the agency, of the guidance itself?
I mean, off the top of my head, I think substance matters. I think process also matters. I think you get better substance when you do better process. That's generally true in my view. And agency leadership have communicated a real desire to engage more with the public. I think that's commendable. I think that's a good thing. But I think we have to take, our own language seriously. So I would like to see us, if we're going to engage with the public on a proposal, put it out for more comment, have more discussion, invite not just the views of other commissioners, but really the public into that. So I think that process stuff is important. My issue, you mentioned this report we put out on online harm. So this is, Congress asked us to do a study of how well AI works to deal with certain online harms, which Congress identified. And I voted against the study because I just didn't think it was as well done as it needed to be. And in particular, I thought one of the things you'd want to do is talk to the people, the companies that use AI to deal with these harms, to get a sense of how it's going. You're going to get some bads, you're going to get some goods, but you want to know, how is it working? And I felt like mostly we just relied on, with all due respect, kind of reporting and academics, and very little engagement with the people who are struggling with how to deal with these harms. I don't think we have to believe everything they say, but I think that's an important part of that discussion. I think there's been some agreement on substance on some things. There's been some lack of agreement. I think, when it comes to antitrust, there's probably a bigger gulf. When it comes to mergers, there's a big gulf. That's part of antitrust. And I think, we're going to see how that plays moving forward.
Yeah, merger is a very good case in point, where you have the withdrawal of the merger guidelines without clear guidance or clear engagement. Let's move on to a broader questions, because I think definitely being at the head of the Federal Trade Commissions, you have to have a view on capitalism and what it means for competition and regulations, and also this process of digital innovation that we see all around, and how to regulate digital disruption. So what are your views on capitalism, and where do you think American capitalism is going? Is it going toward a good directions, bad directions? What are your views on the current state of capitalism?
So before we get to the current state, I will just say, I believe very deeply in capitalism. If you go back and you pull the tape from my nominations hearing, I say I think the market is the best way that we've found as a species, right, to increase the size of the pie and to make sure that goods and services get to the people who need them. To my mind, my rough read of history is that where the more we've deviated from that idea, from kind of Adam Smith on forward, the worse off people have been. And we have seen the greatest growth where we have allowed markets to do the job that they do best. Again, like supply meeting demand, and giving people what they want, what they're expressing, through the market, through what they're willing to pay for things, a desire to have. I think underlying a lot of the debate over antitrust, one of the things that I have observed is that there is definitely a view, not among all, but among some, that the fruits of capitalism, the profits, are mostly achieved, for lack of a better way to put it, through predation, right? That, the old sort of saying that behind every fortune lies a crime. I don't agree with that. I think mostly the fortunes that last the longest, even if they're achieved partially in bad ways, result from meeting consumer demand, meeting needs that the market has. And if you approach the world with a lens of predation, I think you want to condemn a lot more conduct, and you see a lot more villainy at work. And you can call me a Pollyanna, but I think mostly, a lot of the most successful firms over history have gotten there by doing things that are good, by giving people what they want. And so I think fundamentally, that's part of the frame that I bring. Competition isn't always nice, and competition is a critical part of capitalism. So there are going to be winners and there are going to be losers. But I think mostly the story is a good one. That's thing number one. Here's thing number two. and this goes back to the president's executive order and some of what you see in the public domain, there are a lot of people who are very effectively, I think, using words that are comfortable to those of us who believe in capitalism, like competition, like antitrust, to describe a legal regime that looks less like how we traditionally think about those things. And so in the president's executive order, he says competition and he proposes a lot of regulation. Now, regulation is not inconsistent with capitalism. All capitalist societies have regulation. We need regulation because we have market failure. And where you have market failure, right, regulation is a way to solve that. But I think it is a lot easier to say antitrust or say competition or even, forgive me, say anti-monopoly, and then go and do all the things that are not consistent with that. And you will see, you know, Capitol Hill, wherever, you'll see some people out there touting price regulation and talking about competition. And it's like, those are the opposite.
Or even innovation, the regulation, like a lot of regulation in the name of innovation.
We just had more of government running things. People would develop more innovative products. Why do we believe this?
Right. That.
Where?
Yeah, that's the fundamental questions, and I think it's very important when you have these antitrust technical debates to also relate to a broader picture. And I think one feature of capitalism is the dynamism, right? It's also always an economy that creates and then destroys. That's the process of creative destructions that has been described very eloquently by Schumpeter and others. And there's a risk with regulations, or at least the view that we have of a perfect competition or perfect marketplace. There's a risk of entrenching the very monopolies that we may despise, or these enforcers may despise. Do you see this risk of the regulation entrenching even more the power of some companies, rather than just sometimes letting the market do the prosperity?
Yeah, I mean, think about something like compliance costs, right? So you've got a complicated regulatory scheme. There's a cost to complying with it. You know, if you look at GDPR and privacy, this is a good example of this. And to me, the question is, you know, who bears those costs most easily? Is it like a startup firm and they've got 5 people and they have to, instead of hiring an engineer or a coder, hire a lawyer? That's not so good for innovation. By the same token, the bigger you are, right? Compliance is a scale economy. The more you can distribute the costs of compliance across, you know, the bigger size of your company, the more efficient that is for you, the harder it is for a smaller competitor. This is, you know, to me, when we think about regulation or legislation, the important discussion to have, the critical discussion to have, is one about trade-offs. Like, what is the other side of this thing? Because anyone who tells you that you can regulate without cost, I don't think is being fair, because I don't think that's generally true. Now, if we banned impersonating the government, I think the cost there is very low. But the more complicated the rule, the more it purports to govern or ban conduct that is all or mostly good or not bad. I think the greater the trade-off is. And if I had to wave a wand and change the discussion about antitrust, well, there's a number of ways in which I do it, but one important way is that I think people would be a lot more frank about trade-offs. So let me give you an example. You mentioned consumer welfare earlier. One of the things we have heard from critics of antitrust law today, of the consumer welfare standard, is that it has been too focused on price, right? We've heard this argument a million times. I've sat in hearings and I've listened to members of Congress say it to me. We have, what, 8.5%, 9% inflation right now. I'm not saying it should focus only on price, and it doesn't focus only on price, but these arguments came up in zero, very low inflation environment, in zero price markets. I want the proponents of turning away from price, of allowing for more expensive things so that we can shield less competitive companies, to be honest about the trade-off that they are proposing. Because for years they have been talking about don't focus as much as price. Well, I don't know. A lot of people are pretty focused on price right now, and I don't think they're crazy.
That's very important to focus on those trade-offs. It's not only one-sided. And precisely, let's move on precisely this price and inflation. I mean, some say antitrust is the answer to every social problems, and you pointed out on inflation. So is antitrust, or lacks antitrust enforcement, as some will say, is the real cause of inflation that we see those days? Or because that's the debate where we're in, right?
So I gave a whole speech on this back in January. It's called Inflated Claims. It's on my website. I don't think there is a lot to this argument. It's funny, you saw some politicians making the argument where the prices of certain things were going up. They didn't take away the argument when the prices started to go down of the particular products. Look, a lack of competition can certainly support prices above the competitive level. That's what antitrust is all about. But, you know, the claim is that the enforcement got lax in the 80s and then it manifested in the 21, 22. Like, that doesn't make a lot of sense. And there's a lot of other reasons it doesn't make sense. I think antitrust is still important, for sure. I think we should be vigorous enforcers of our antitrust laws. But I think to look out at the economy and wide inflation that we're seeing, and you know, it's the same people who were calling for the thing before it are like, yes, and this proves my point.
Most of the time, large companies have a deflationary aspect because of scale economies. So because you're larger, most of the time you offer cheaper price, which is a very strong competitive constraint on smaller retailers.
Right.
But most of the time it is deflationary.
Correct. And one of the things I really worry about with moving off consumer welfare, if you're just condemning big because it's big or because it's efficient, right? Because they have a competitive advantage, and that's not a level playing field, is you're asking people to trade the lower prices that they want for the ability of less efficient firms to compete. That is not what the law says. It's not where I think the policy should be. And I think those advocating for this should be honest that they're proposing people to sort of eat some higher prices so that we can get whatever it is they want out of the equation.
We have to be honest in this discussion. That's totally true. But at the same time, you say like that's politics, right? There's a lot of political aspect in the antitrust discourse. So it's politics. Precisely, this leads me to the questions: what's your relationship with politics and political engagement? Have you personally been engaged politically, and what's the relationship between FTC commissioner with politics and political parties? How do you see politics?
Okay. I used to work on Capitol Hill.
Right.
I worked for 7 years for Senator Cornyn, whom you mentioned earlier, which was terrific. Actually, if you look at FTC commissioners today, 4 out of 5 of us have been working in Congress at some point. And in fact, 3 of us worked together on the Senate Judiciary Committee. That's Commissioner Slaughter, Commissioner Bedoya, and me. So all of us have had, well, not all of us, 4 out of 5 of us have worked in, one political arena, and that is the legislative arena. All of us come through a political process, right? We're all nominated by the president, and we're, the advice of consent of the Senate is given on our nomination. So in that sense as well, I think, politics impacts what we do. Also, historically, there's been sort of a joke about the FTC that, we're independent of the president, but not so much of Congress. And we will get lots of, what we call congressionals, but letters from Congress, lots of input from Capitol Hill. In private conversations, if you ever see us testify, people always have their issues that they want us to solve. So we interact a lot with the political process. And in fact, our statute says that, no more than a bare majority, no more than 3 can be of the president's party. So there's kind of politics, if you will, built into the structure of the thing. But I do think that part of the design of the agency is supposed to be on some level removed from politics. That's where the independence comes from. That's where the fact that not everyone is of one party comes from. There's sort of a goal. I think there's a lot of questions in terms of the constitutionality of the thing, but the design of independent agencies is to be a little bit divorced from politics. We're supposed to be more expert than we are political. And even if we come from the political world, we're supposed to look out at it and and do our best to approach that sort of ideal of expertise. So I think, we can't help but engage with the political process, but we are not supposed to be politicians. And I would be a very bad politician if I tried to be.
Yeah, that's a very interesting tension between the independence of the agency, but also coming from the political nomination. It's very interesting to, I guess, in the daily work of the agency.
I should add something too, which I think is important. Not our only role, but a very important role that we at FTC have is we're law enforcers. And even if a law enforcer isn't independent, right? So the Department of Justice doesn't have a statute that protects its leadership from being fired by the president, but there is a strong norm of independence from the president. And in fact, this created a real problem in antitrust in the Nixon administration. So the Nixon White House was trying to use antitrust to sort of punish its enemies and reward its friends. And Congress passed a law called the Tunney Act. They can't do a settlement without a judge approving it. The reason they can't do that is because there was a worry that where law enforcement is doing political work, things go awry, and that's a bad thing. And I think fundamentally a lot of Americans understand that.
And that's also explained the rise of the consumer welfare standard to try to rationalize and to divorce antitrust from politics to some extent.
So I think it's less divorcing it from politics. I think it's trying more to add clarity. So there's the old joke, right, that if your price is too high, you're extracting a monopoly rent. And if your price is too low, it's predatory pricing. And if your price is the same, you're colluding, right? So this is the joke that, to some extent undergirds the critique that Bork and others were making. It's the antitrust paradox in 1978 for a reason. The law didn't have as much clarity and there wasn't a good way to judge. And consumer welfare was an effort to sort of do two things. First of all, add that clarity and also examine some of these presumptions that courts had created, that conduct was bad, examine whether in fact that was true. And in many respects, it turned out not to be so.
Right. Let's move on. So you are born in Boston. And you received your bachelor's degree from Dartmouth College and your GD from Stanford Law School. So antitrust has received so much press coverage and over the last few months and few years, and also because of the enforcement activities of different agencies across the world. What would be your advice to the younger generations as to someone who's either in the law school or think about going to law school or in the economics department of a university? What would be your advice for perhaps the next generations of antitrust scholars and enforcers?
Ooh, I guess the advice it would depend on what they want to do. I mean, my advice always is to study hard. To see whether you find a field of law to be interesting intellectually. I think that's really important to being happy in the work that you do. I didn't set out originally to be an antitrust enforcer. So that leads me, I think, to the most important advice that I would give to any kind of lawyer, which is just grasp that your career may take you in places that you don't expect. And that may happen because of opportunities that arise that you didn't expect, or just because life takes you in a direction you didn't plan to go. I didn't plan to live in Washington, D.C., but I got married and my wife wanted to be here. So here I am.
Right. And also for to practice or antitrust, or you have to have these interdisciplinary skills, both law and economics, right? And what would be your advice on how to develop those interdisciplinary skills, to be just curious about everything law related, economic related?
Yeah, I mean, I think it's good to have an adequate dose of both, right? Because those are two languages which practitioners need to be conversant. If you look at how cases work, that's important. I think, yeah, that's the most important advice I would give about that.
What's the value in life that you hold dear? What would be the value?
I mean, I think honesty.
Honesty. All right.
Yeah,
all right.
I think honesty is very important.
And right. What was your favorite offer Do you have any
Oh,
book?
yeah, that's easy. Philip Roth is my favorite author, who is a sort of,
Why?
oh, I think he is as good as good an observer and as good a describer of sort of modern America,
Mm.
particular modern urban America, and how it came to be as anyone else.
Right. General question on we talked about antitrust competition, but also let's broaden up to the global stage. Do you see any relationship and or intentions between competition antitrust and competitiveness of America and of nations specifically, like how you create a competitive marketplace and how that competitive marketplace has an effect on competitiveness, but also how you have some time, I mean, going back to Roosevelt's ideas of like sometimes suspending antitrust for creating national champions or for times of war, you know, this kind of issue of how you see antitrust in a more strategic competitiveness angle.
Sure. So I think it's important to table set that I am not like a geostrategist, and I don't do national security, that kind of thing. You see in the States and in Europe, there's fracas about this in Europe not so long ago, an argument from time to time that we should suspend the enforcement of competition law in order to sort of artificially support firms as national champions because national defense or whatever. I don't agree with that. I think the rule ought to be competition. Now, and so where the company pleads, but we're special for this, that, or the other reason. If the government is going to displace competition, the best way to do it is for the world to be very clear about what we're doing and for political accountability for that to be in the right place. Quietly whispering in the ear of an antitrust enforcer is not the right way to do it. And there are, in fact, some countries where the competition enforcer, like in the law, can be big-footed by like a national security authority. There's a flip side to this, though, as well, I think, which is that if you relentlessly beat up on your own and you're not just protecting competition, I think part of American greatness, forgive the phraseology, comes from the fact that we have allowed our companies to compete, that our default has been more freedom than it has been regulation. And I think that has increased our national power writ large. It's increased our economic wealth. It's increased the innovation and dynamism that help, it's right. The geostrategists talk about soft power. It's not all tanks and guns. And what I don't think we want to do, I think you can overdo it. And just relentlessly beating up on our own without a good theory of how the law is being violated, I don't think will strengthen us in the long run.
Right. Yeah, it may create some arbitrariness or discretion that foreign powers will retaliate against. When it comes to the notion of liberty in the marketplace, where would you say, like, closer to the idea of liberty as free enterprise, businesses being free, or the freedom to survive and compete in the market so that you protect more the market structure and every firm has a right almost to operate in the market?
Oh, definitely the former.
The former.
Yeah.
Right.
I mean, the latter is, put differently, it's government help for those who are losing in the competitive process.
Right. And yet it's a very much the European idea of outdoor liberalism, the idea of every company has a right to operate in the market. So that's precisely also may explain the divergence and discrepancy between US antitrust and the European version of competition.
Yeah, I mean, everyone has a right to compete, but what I heard you describing was more, and so you need the government to help you to the point where you're equivalent to who your rival might be. Now, as I was saying before, with respect to some of the state laws that we at FTC do work against, you don't want government barriers to that competition. But not everyone is going to start out at the gate with the most efficient means of production or the most efficient means of distribution, right? You're going to, in capitalism, you have winners and losers.
Right. More personal questions. What aspects would you like of the American society? Would you like, you wish your children would keep having? And what aspect of the American society you wish your children wouldn't have?
I mean, look, I think we have a society fundamentally built on ordered liberty, where you can pursue the family and the faith and the friendships, all the things that are valuable. I mean, we've been talking a lot about the economy, so you can also pursue profit. I think fundamentally, like, I want my children to have the opportunity to have access to the things that have brought richness. I don't mean richness in the sense of material wealth, but richness to my life. Like, I want them to continue to have that. I would like them to have less screen time. But I am mindful of the fact that my father also would have liked me to have less screen time.
That's right. That's the dependency to screens that is increasing throughout generations. Final question, perhaps. How do you define progress, general progress? More innovation or protection?
I mean, I think the nature of the question suggests the answer, right? It has to be innovation. There are times when there are things we want to protect,
Right.
but we don't think about that in terms of forward progress. I think from an economic perspective, while we do think and we should think about pie distribution, it's also really important to remember that the more pie you have, the easier it is to distribute.
Final question, Peppa. Is there a life after antitrust?
Yes.
All right.
I hope so.
Thank you so much, Commissioner Phillips. It was a great pleasure to have you for kicking off this new series of episodes. And we look forward to follow your work at the FTC. And yeah, we'll see you next time. Thank you.
Thanks so much for having me.
So thank you so much for the audience for watching us and being here. So please like and subscribe on episodes on YouTube. For more content, just follow Schumpeter Project and Competition Policy at ITIF YouTube page. And yeah, see you around. Thank you.